Happy Wednesday, everybody. Thank you so much for joining us. I'm Tammy Welty. I'm the Director of Training and Communications here at Bradford Barthel. John Kamin is leading today's training on Lien Statute of Limitations. And we have Nikki Zahler joining us from our Woodland Hills office, and she's going to assist with questions today. Let's move into introductions. Nikki, do you want to start us off?
Sure. Good afternoon, everyone. My name is Nikki Zahler. I am an associate attorney with Bradford Barthel, and I work out of the Woodland Hills office. And a little fun fact about me is, even though I was born and raised in California, I am an avid Steelers fan, and I look forward to the upcoming season.
Nice. I love it.
And good afternoon, everybody. My name is John Kamin. I'm a partner in Bradford Barthel's Woodland Hills office. I'm also director of the firm's editorial board, which is a fancy way of saying that I run the firm's blog. So if you have any blog ideas, please let us know. And we're always happy to hear from you. Our best ideas come from you. And Tammy is actually probably going to ask you a little later in today's presentation for some blog ideas. We have a little survey thingy we do here in the Zoom presentation. And a bit of background about myself. I was a journalist in Arizona, worked for a few newspapers there, and then also worked for Work Comp Central as the legal editor there for about 6 years. And football, for me, I'm a Cardinals fan, so lots of years of just painful seasons, but this year things are finally looking up. So hopefully everyone stays healthy. Fun fact about me, while I was working at those newspapers in Arizona, 20 years ago, there were a lot of fires. So I remember going to one fire and taking pictures and video and all that. And I was near one of those fire tornadoes, which is about 100 feet tall. And so when you're about 100 feet, when you're about a half block away from that, the temperature is like around 100 degrees as well. And what they don't tell you is the wonderful smell that you get when you're near a forest fire like that. And so when I went to the newsroom to type up my story, my coworkers were like, "Can you just get out of here and go take a shower? Because you're stinking up the whole office." So I went home and took 3 showers, and that finally got it off me. But anyway, let's go ahead and get started. Well, here's what we're going to cover today. We're going to cover the Lien Statute of Limitations, second bill reviews, essentials for every exhibit list, med legal dates of service, and liens. And we did have someone submit a question for med legal dates of service and liens, so I will touch on that question later on when we get to that as well. So let's start with the Lien Statute of Limitations. Very simply put here, if you have dates of service before July 1st, 2013, your statute of limitations is 3 years from that last date of service for them to file their lien. If the date of service is after 7/1/13, then their statute of limitations is 18 months from that last date of service. And so what I do every time I get a lien case, I basically run through this checklist. So on one screen, I'll pull up my itemized statements for liens. I'll have a window with my EAMS public search lien search for your case. And I want to compare the last date of service on that itemized statement for, let's say, ABC Lien Corp, and compare that to the filing date on my EAMS public lien search. And so if a recent case, and if it's more than 18 months, then it's probably barred by statute of limitations defense. So again, if you have 18 months between, or more than 18 months between that last date of service and the filing date, it's barred. If it's a pre-2013 case and more than 3 years between last date of service and your filing date, that's probably barred by the statute of limitations. So our first example, just this stuff is kind of easier to go through if we do it by example. So let's take an example of Frankenstein Chiropractic. Their first date of service is February 1st, 2012. Last date of service is August 10th, 2013. Their lien is filed on February 9th, 2015. Is it barred or is it timely? It's actually timely because the last date of service is after 7/1/13 Remember that last date of service is 8/10/13, so we're using the 18 months. And the lien was filed 17 months and 30 days after that last date of service. 17 months and 30 days is 2/9/15. So with 2/10/15 being exactly 18 months from that last date of service, that makes this particular lien claim timely. So one question that I get every now and then is, well, their first date of service was actually before that July 2013 deadline. Does that matter? And what you want to remember is, no, it actually doesn't matter. And over the years, in 2013 and later, through about 2016, a number of lien claimants tried to use the 3-year statute of limitations by saying, hey, we did have some dates of service in 2012 or whatever. Well, there's a number of panel decisions saying that, no, you can't use that to go back and use the older statute of limitations. So really what controls is that last date of service. And here, the last date of service in this example is 8/10/13. So one other thing that came up while I was drawing this up is when you're looking at chiropractic liens, especially on older cases where you may have had a ton of medical treatment, you want to do a quick application of the 24 visit cap, because while the 24 visit cap has exceptions, most cases don't hit all those exceptions or don't hit those exceptions. So in this example, you'd want to count how many dates of service did Frankenstein Chiropractic have, check your liens of record list and see how many other chiros treated on your case. If more than one, well, you want to matrix that out, see who provided the first chiropractic treatment, when was 24 visits hit, do any exceptions apply to the 24 visit? And often what you'll see on these cases which got dragged out for a while, often the reason why they're dragged out is numerous QME panels, for example, is basically you'll often see that like that second and third chiropractor being 24'd out. In other words, they have chiropractic treatment after the 24 visit cap, and thus you can use that against them in arguing their lien. So yeah, while chiropractor number 2 or number 3 may have a timely lien filed, that doesn't mean that you have to reimburse them if they're barred by the cap. So moving on to a second example, Bram Stoker's toxicology lab. So first date of service is January 1st, 2016. Last date of service is August 1st, 2016. Or sorry, last date of service is August 1st, 2016, and lien is filed on February 26, 2018. But wait a second, when we look at the itemized balance, we see a shady date of service at the end for 9/1/16. And it isn't quite clear what that is for. Is the lien timely filed? Probably not if the last date of service of 9/1/16 is some made up thing. And what tends to happen sometimes is sometimes someone in the collections office will realize that they blew the statute of limitations. So in this example, the statute of limitations would have expired on, let's see, yeah, it would have expired before their filing date. And so what you may have happen is you may have a collector fabricate date of service before the end date, basically before the statute of limitations expiration date, to preserve their lien. So mistakes, and that's misspelled intentionally, mistakes happen. It's a volume business and these liens are handled in bulk. So if the lien wasn't filed timely and you see a mysterious date of service at the end, you want to ask about that and see what that is, see if there's a medical report for it. If there's no medical report for 9/1/16, then you apply the statute of limitations to the date before that. So definitely question those last dates of service, see what they're about, see if there's a medical report for them. Make sure that they just aren't some made up thing. So going to a third example, first date of service is 12/1/12. Last date of service is July 10th, 2013. Lien filed on October 9th, 2015. Well, that's more than 2 years after our last date of service. So it's untimely because 10-9-15 is more than 18 months after that last date of service. Frankenstein is going to say, well, our lien is filed 3 years from the first date of service, and they're going to argue that that's okay. No, that doesn't fly to what we said earlier. There's a number of panel decisions that say you can't use the first date of service like that to try and get the prior statute of limitations to apply. The last date of service is what controls which statute of limitations applies. Another thing that SB 863, oh, and Nikki, do we have a question?
I do. So here's one. A lien was filed timely, but payment failed and was resubmitted. Payment was cleared a day or two later. Is it still considered being filed timely?
Let's see. And so I'm sorry, could you repeat the question one more time?
Sure. Lien was filed timely, but payment failed and was resubmitted. Payment was cleared a day or two later. Is it still considered being filed timely?
Oh, so that's the lien claimant's payment of their lien fee. So I think in that situation, that's a close call. So yeah, I think that one's going to come down to proofs of service and when payment was actually issued and all that. I lean toward that one being untimely, personally. And yeah, so personally, I lean toward that one being untimely because the payment was made. They had 18 months to do this, and they waited until the last second. So that's why we don't wait until the last second, because then bad things happen. Any other questions, Nikki?
I'm receiving a lien, but no hearing is being set yet. What's your thoughts with those?
Oh, okay. So with those, you probably want to, if the case in chief is settled and you want to get things moving with liens, if you don't want it to drag out, often what we'll do as defendants is send out a letter or two and then file a DOR for a lien conference. So that's a good way to get the ball rolling on liens. That'll wake them up when they see that there's something on calendar.
And then I have one more. What are some arguments against copy services alleging that they are med legal service to try to get around the fact they failed to file a timely lien? We are seeing a lot of old billings, some 10 years old, resurfacing, arguing they are med legal and not subject to filing a lien.
And I've seen that as well, too. So I actually was working on one of those a few weeks ago, and I did a deep dive because ironically, this was a file I had worked on 10 years ago. And I think I closed it 10 years ago. So when I had to reopen my file for a petition for non-IBR from a copy service with 2 dates of service, I did a deep dive on that. And I checked out the panel decisions. And I found a bunch of panel decisions giving that lien claimant the benefit of the doubt and giving them victories. So to answer your other question about what constitutes a med legal service, the definition of that always boils down to this one sentence. Was the service necessary to prove or disprove a disputed fact or a disputed issue? So if the case is denied, you have lots of disputed stuff. So if you have copy service, dates of service, while the case is in a denial phase, the appeals board at the San Francisco Appeals Board, so the appellate level, they're going to rule that it was a med legal service. So that's how they're interpreting them. What I did notice is that in the panel decisions on that topic, where you have copy services from 10 years ago, now filing petitions for non-IBR in 2024, is that even though their subpoenas were flawed in 2014 or longer ago, the board is saying that that does not bar them from pursuing recovery as a med legal lien either. And we will touch on med legals at the end of this presentation a little more. So trust me, we will get to that. But yeah, I did want to mention that recent batch of panel decisions, which are finding in favor of the lien claimants with these older copy service liens. So one thing I did want to touch on real quick is going back to Senate Bill 863 when it became law in 2012. Before it became law, lien claimants could argue that the statute of limitations was tolled until the defendants served settlement documents on the lien claimant. Well, SB 863 did away with that. They amended the Labor Code section 4603, and they tied the statute of limitations to the last date of service. So that simplifies our statute of limitations analysis. So if you do have people arguing, hey, you didn't serve me with the CNR and that told it, no, that doesn't fly. It's last date of service and filing date. Group health liens do enjoy an entirely different statute of limitations. So this Labor Code 4903.5 subsection B gives group health plans 1 year after they knew or should have known. And so what's new or should have known? So when should they have known? Well, I would argue that the group health provider knew that the applicant had a work comp claim, and this is going to start our 1 year statute of limitations, when they wrote down on their intake forms that this is a work injury. Well, that means that the group health provider has 1 year after the applicant wrote that down and handed it to them to file their lien. Another way that they get put on notice is if the applicant tells their personal physician at the group health provider that, hey, this injury is work-related. Sometimes we'll subpoena records, and we'll see that mentioned in the report, in those subpoenaed records. The last one is arguable. Speaking of subpoenas, I, the defense attorney during a case in chief, will send group health providers a subpoena looking for pre-existing stuff. Of course, my subpoena says the name of the case and the ADJ number. I would argue that that puts them on notice that, hey, there's this legal proceeding with your applicant over here. Can you respond to this official subpoena from this work comp case? So I argue that that's notice as well. It's literally sending them a legal pleading and knocking on their door and saying, hey, give us your records. We need them for this case. So I feel that that's pretty clear. You know, those subpoenas come with the proof of service, and the group health providers do respond to them. So here's a group health example. Harvey Dent, our applicant, goes to see a dermatologist and plastic surgeon at his group health provider. And while filling out intake forms on July 18th, 2008, he checks yes to, are you here for a work-related injury? And he's effectively put them on notice, so they'd have until 7/18/09 to file their lien. So let's say they do file a timely lien before 7/18/09. So now we're sure that they have timely filed. One thing we're kind of trained to do when we work on liens is, well, let's look at fee schedule. You know, it's timely filed. We may have other arguments against it, we may not, but let's get a bill review. Well, for group health liens, fee schedule is probably not your ticket to victory. And the reason why is that group health providers and health insurers have this web of contracts that often create discounts that make their billing for each date of service much lower than fee schedule. So if things are being done correctly, to be honest, your work comp bill review expert's official medical fee schedule valuation is going to be higher than the bill that the group health guys are asking you to pay. So what you start looking for other defenses, and those other defenses are, which body parts are they treating? So if Harvey's face was the only industrial body part, and group health is treating and billing you for a non-industrial broken knee, then that's arguably non-industrial treatment. So yeah, you want to go and check out the body parts. What were they treating for? Often they are treating for all kinds of stuff that isn't related to the work comp claim. So depending on how simple or how complex your work comp claim is, that's going to go to this body parts defense against group health liens. And so another thing that you want to be aware of, and someone touched on it already with that great question, is liens with dates of service after 7/1/13 suddenly had to pay an activation fee of $150. And there was some litigation over that, as you remember, but eventually they had until December 31st, 2015 to pay that fee. So if they didn't pay that fee, then they were dismissed by operation of law. So if you have liens from that time frame, 2014, 2015, that never paid their fee, then they're dismissed by operation of law. Many of those have already been purged by Eames. So Let's move on from statute of limitations and move into our second big topic, second bill reviews. So on your steps and issues or your pretrial conference statement, on your issues page, you want to list second bill review or second bill review not requested, and or these statutes or regs listed up there on the top of the slide. Now, in situations where the only dispute is the amount of payment, a provider with data service on or after July 1st, 2013 must ask for that second bill review within 90 days of receiving that EOR that they disagree with. And they have to send it back to the TPA with a long list of other items as well. And here's the long list of other items: original data service and same itemized services, date of the EOR that they're objecting to and its claim number and other identifiers, the item and the amount in dispute, the additional amount of money that they want and why, the additional info provided in response to a request for the first EOR. Sometimes EORs will have questions for them. So if they do have additional info to answer those questions or to support the lien claimant's case, they have to improve that. They have to include that too. And some doctors, managers are really good about second bill reviews. So if you see that they made a valid request, then it goes back to a dispute, and the defendant needs to issue, a new EOR or EOB. Some office managers are not good about second bill reviews, and they never ask for them. And if they didn't request it in an accepted case where fee schedule is the only issue, then their date of services are effectively knocked out. And keep in mind, second bill review process only applies to official medical fee schedule disputes. So you want to keep that in mind as well. One fact that does come up in lien cases, which I'm sure you've seen before, you have a denied case and the bill review department, the bill review department creates a bunch of EORs and EOBs which say non-payment because this is a denied case. So 000, it's all zeroed out. Well, if the case is later accepted and becomes compensable, then those EORs are essentially worthless. Now, keep in mind, those EORs were generated while the case was denied. So official medical fee schedule was not the only dispute. So as far as using those EORs and EOBs as exhibits, they don't make for great exhibits either, because they're kind of not relevant anymore. And when this situation pops up, when you have a case go from denied to accepted, you want to get those bills reviewed again. And speaking of denied cases that become compensable, when you're working on a case in chief and you do have a denied case with UR deferrals of RFAs, what that means is utilization deferrals saying, hey, this case is denied, so we aren't going to make a decision on your RFA, doctor, until we aren't going to make a decision. We don't need to. UR is deferring. But then later on, you decide to accept the case based on a QME report or some kind of medical reporting. Well, you have up to 30 days from the determination of compensability to submit those to retrospective UR. So determination of compensability could be the day you decide to accept it. It could be a findings and award on an AOE COE trial. So 30 days after that. So you want to get those to retrospective UR. And what that's going to do is it's going to weed out the frivolous stuff, such as services that are not reasonable or necessary under the MTUS or ACOM guidelines. So yeah, definitely recommend the retrospective UR. That's one way that defendants can save a whole bunch of money, is by using that properly. So keep in mind when you are accepting a case, send those RFAs back to UR and get those decisions in, and that'll help you out. Now, while preparing for a lien conference, I list a lot of stuff on my exhibits list. And so these include delays, denials, EORs, EOBs, URs, IMRs, QME reports, other helpful medical reports, subpoenaed records. If you are arguing 24 visit cap, those other medical reports that get you up to the number 24. So you want to list those as exhibits. The sub rosa video, if you have it on a case. Applicant's deposition. Also witnesses, not just employer witnesses, not just the applicant, but also fee schedule experts. And while I may not list, or I may not actually use all of these exhibits, sometimes you have lien claimants who pull arguments out of left field. So therefore I overlist and I actually only use some of that stuff as needed. But yeah, it's because lien claimants will produce arguments that sometimes are unexpected. It's better to overlist, be over-inclusive. That way, if you do need one of those things, you can say, hey, Judge, I did list that on my pretrial conference statement. Now, there is an alternative view of looking at exhibit list as well. And this one is a valid, it's definitely a strong argument for it. So in your denied cases where lien claimants have to struggle proving AOE COE, it's their burden to prove AOE COE on a denied case. There are some defense attorneys who prefer this theory of exhibits. You simply list the delay and denial and maybe some bill reviews, and that's it. And this is the less is more approach. It basically puts the burden on the lien claimant to prove their case. And if you've talked to a number of judges, one common comment from judges who've done lien trials is, I can't believe the defendant shot themselves in the foot by listing those reports saying that the case is compensable. So it's a case-by-case consideration. On some hands, or in some cases, you don't want to shoot yourself in the foot by including QME reports. But in other cases, the QME reports can make the PTP's treatment look really frivolous. So you just want to really know the facts of your case and know, gee, is that QME report going to help me fight these liens or not so much? That being said, you definitely still need your denial, and you want to list something with fee schedule valuation. So if you do lose, you don't get hit with the full balance that's being billed, but instead you get hit with fee schedule. Another theory toward the order of lien settlements. So let's say you're at a lien conference and you have 10 lien claimants. There's sometimes value in settling liens in a particular order. So for instance, one can create a strategic disadvantage with exhibits in this scenario. So the case is set for lien trial with 10 lien claimants, and you have a PTP, a toxicology lab, secondary treater, DME, interpreting, med legal services, and non-physician lien claimant. So like that DME is a good example of that, I guess. So often the PTP is the one who has the best exhibits. They have all the medical reports saying, this person had this injury on this day, and here's what's going on with them. And those may have the best narratives in favor of the lien claimants. And meanwhile, your other lien claimants may be missing a plethora of reports on their exhibit list, and they're actually relying on the PTP to help them with their burden of proof. Now, keep in mind, we're set for trial. The pretrial conference statement is complete. No new evidence can come in. You're going to object to it if they try and bring stuff in. So the approach here is settle that PTP first. They're no longer going to participate in trial. They're pulling back their exhibits. And now suddenly the other lien claimants who did a sloppy job on their exhibit list suddenly don't have all those great things that the PTP had listed. So if you've settled the PTP for a lower percentage, you can also brag about that to the other lien claimants too. Like, hey, the PTP settled for 25%. Normally they're looking for more than that, or they settled for 15%, whatever the number is. But that's going to inform the other lien claimants about the case. And hey, the PTP didn't think that this case was worth much. And if you're having difficulty with a particular lien rep, you don't think that they're conveying your information, after that lien trial date, often you'll have people in-house, the in-house collectors reaching out to you between lien trial dates. Well, you can make sure that, the in-house supervisor is aware of what the PTP settled for. And those people, if you have a courthouse lien rep not taking you seriously, sometimes the in-house people will take stuff like that more seriously. And so here's a question we touched on earlier. What is and what are not med legal services? So here's our definition again on page 37, slide 37, if you do need that. So prove, disprove, disputed issue, or a disputed fact in a contested case. And here's this reg 9793 subsection H. Any expenses or cost incurred for x-rays, labs, diagnostics, medical reports, medical records, medical testimony, and as needed, interpreter fees for the purpose of proving or disproving a contested claim. So what's a contested claim? So denied claims under number 1, or claims where a administrator has failed to accept liability for a claim, and the claim has become presumptively compensable under 5402. Another example of a contested claim is where the TPA has failed to respond to demand for payment. That can be contested under CCR 9793. And the fourth criteria pops up a lot, where a TPA has accepted liability for a claim, but disputed medical facts exist. So number 1 and number 4 under this reg are the ones that come up the most often. Number 1 is obviously denied claims. Number 4 is claims where, sure, we've accepted, but we have disputes over body parts, for example. That comes up all the time. Disputes over PD, so that could be apportionment, disputes over temporary disability. So our takeaways from this is it's easier for the lien claimants for providing med legal services to qualify as med legal in denied cases. And it's also easier for them to fall under the med legal definition if there's a disputed medical fact, such as the stuff we just talked about. So here's an en banc decision it's the Monaco decision. This came out 5 years ago. And your takeaways from this is that your copy service lien claimants must prove that A, there is a contested claim, B, the services were incurred for disproving a contested claim, and C, the expenses were reasonable and necessary. Monaco also said that a failure to issue an EOR does not constitute a waiver of objections. Now, that being said, we still recommend issuing EORs or some kind of objection to copy service liens. So what qualifies as med legal expenses? So QMEs and AMEs, of course, you look at the statutes and they talk about those immediately. Interpreters at court hearings. So at courthouse hearings, your interpreter who helped out with the hearing, that's med legal. Copy services in cases with any disputes. And as we talked about earlier, even your copy service dates of service that are a decade old, they're winning at the appeals board, even when they have procedural flaws, such as not serving the defense attorney with the subpoena and instead just sending that subpoena to the subpoena target. Sometimes PTP narrative reports that comment in great detail on disputed issues, those can sometimes qualify as med legal expenses. Often that's the initial evaluation report and the final MMI report, because those are the ones with the narrative stuff. The ones in the middle where it's just copy pasta and not much narrative in them, those are more treatment, and those are going to be fee schedule. But there is a basis under panel decisions out there for these longer narrative reports to qualify as med legal. And Nikki, we have another question?
Yes, we have several coming in regarding copy services. So for subpoenaed liens and bills, can we object on the basis of them not sending us a copy of the records they are billing for?
So yes, actually, as far as that, under the copy service fee schedule, if you do ask for a copy of the records, they charge you approximately $30. So that's not really a basis for objecting to their lien, that particular line item, no.
And then also someone is asking, what is the going rate for half a day service of interpreting at the board for Spanish interpreting, if you happen to know that?
So for me, frankly, I'm still arguing $90 per date of service, but obviously with a half a day of interpreting, you see lien claimants, you see interpreters charging a lot more. I've seen clients pay $150. That's reasonable. I've seen some pay higher than that, but that's pretty rare. So yeah, I personally, on my cases, I'm still using 90 per date of service. And if it's a case where we have a strong defense, I may use that. And so, for example, let's say there's 10 dates of service, 10 times 90 is 900. But I also have a strong defense that the case, was not even compensable. Well, in that case, if I may recommend like $450 and cite my evidence showing that, hey, this was a weak case or something like that, or $400 or $300. So that's one way to kind of look at it. Is you take the fee schedule, or what you think the appropriate rate is, and then you kind of multiply it times what your odds of prevailing are, or what you think it's worth. And so that's one creative approach you can use to cut down on those interpreter liens. And as we touched on earlier, the interpreters may not have the greatest exhibit list. So if you can knock out the PTP earlier in the case, that can weaken the interpreters sometimes as well. Now, another place where med legal and that, this definition that we keep on talking about comes up is in contribution reimbursement. Contribution reimbursement, we can get back pro rata shares for treatment and stuff like that. But also in contribution reimbursement, if it's med legal, suddenly we can get 50-50. So if you have 20% of the last year of injurious exposure, you're going to be rooting for that stuff to be treatment, because then you're only going to owe 20% of whatever we paid. But if I can point out that, hey, that's a med legal service actually, then I have a strong argument for you to pay 50% instead of your pro rata 20%. So it's good to keep those in mind too when you come around to the back end of a case and you're analyzing it from a contribution perspective. So when I'm going through a client's benefits printout, I'm actually checking ML for med legal, or is it treatment? Most of the stuff is usually treatment, but in some cases you do have a lot of med legal things on there. So it's worth keeping that in mind as you're looking at contribution. And obviously, you'll be on one side of contribution today, and next year you'll be on the other side defending against it. So it's just something good to keep in mind. Here's a takeaway on copy services, and this touches on what I talked about earlier. I had that old lien, and they filed and waited 8 years. So the client had actually destroyed their file. I wanted to argue latches, but the numerous WCAB panel decisions that I looked up are making it really easy for the copy services to prevail as med legal services, even in situations like this where they waited 8 to 10 years to pursue those dates of service. These panels do ignore some threshold arguments, such as whether the copy services subpoenas were defective. An example of defective is defective service means that they didn't CC me, the defense attorney, on their subpoena to, let's say, West Hills Hospital. Well, according to these panels, does that defeat their lien? No, not according to these panels, it doesn't. My issue with that is that because they didn't CC me, the defense attorney, how am I supposed to file a motion to quash? I can't if I don't know about it. And then, when it's my turn to litigate that lien, the copy service is going to argue, well, John, you didn't issue a motion to quash. How come you didn't do that? Well, I didn't know about it. You didn't serve me. So I feel like that's kind of a hole in these current panel decisions that are out there. What about failure to prosecute their timely filed lien? Does that bar them from recovery? No, not according to these decisions. They're letting them come back years and years later. So while I disagree with these results, I disagree with them because flawed subpoenas should not be reimbursable. But that being said, they still are finding favor at the appeals board. And Nikki, do you have another question?
Yes. For files that were previously resolved by a stipulated award and remains open for future medical care, are we liable for copy service invoices requested by the applicant's attorney?
So that's a good question. So there's a few follow-up questions I would ask to that. Is there a petition for new and further, for example? If there is, then you may fall under the definition of contested claim that we talked about earlier, because now they're saying, well, wait, there's more PD or more TD here due, or more body parts. Often applicants will try and work in more body parts with a petition for new and further. So it really depends, because we've also seen those cases which resolve via stipulated award where there's not much going on. For example, if the applicant isn't treating, or even if they are, but there's no dispute, there's no arguments, and it's past the deadline for petition for new and further, then why are those necessary? I'd argue that those are not necessary. And so those are some thoughts to keep in mind when you're analyzing it. But that is a very good question. And to give you a very lawyer-like answer, it just depends on the case, unfortunately. So, what else, Nikki?
Does the 3-year statute of limitation bar copy servers that fail to ever file a lien?
And the answer to that is no, because they're med legal services. So they are actually technically not lien claimants. While some may still be proceeding under the lien claimant theory, that's why we're seeing petition for non-IBR, because they're arguing that they're a med legal service. And med legal goes back to that, are they helping prove or disprove a disputed issue or disputed fact? And any other questions?
Are copy services eligible for payment when they secure records for IMR filings?
Oh, yeah. So that's that. You know what? That is one. Please email us afterward. And my email address is at the end of this presentation. That's a really long answer, and I don't want to derail this, but it's kind of tricky. I don't think they should be using copy services for IMR. So personally, that's my lane. I just don't think that they should be doing that. I think that it's the applicant's attorney's office. So I think that is kind of inappropriate. And I just want to touch on I did want to touch on advice as far as petitions for non-IBR in lieu of these panel decisions. We are happy to fight the good fight and make arguments against these. Usually the best ones to fight are PTPs. The ones that are often not as worth fighting are the copy services, if it's a true, just like standard subpoena during a denied part of the case, or when something's in dispute. We have one at trial on stuff like this, only to be overturned a year later at the appeals board. So I've seen multiple decisions involving copy services where defendants won at trial, only to be overturned at the appeals board level. And so that presents us with a interesting quandary when we see a bill for $500 for some date of service from 2015 that wasn't paid. I'm happy to go and litigate that for you, but do you really want me to go, spend a year fighting that, or at least a few months at lien conference and trial, when it is a $500 thing and we are seeing these getting overturned at the appeals board level? Now, what bothers me about the copy services out there in our current system today is it's rife with abuse. And a great example of abuse is getting 3 subpoenas for the same location in 1 month from an applicant's attorney's copy service, where I know the applicant's attorney didn't request them first. And here's another example of abuse, is I've had a case where applicant's attorney and we have a settlement agreement. We're just waiting on CMS to issue their determination letter on whether they like our MSA or not. So there's no treatment, no nothing for about a year. I receive a new subpoena for an old facility that applicant hasn't treated at in like 5 to 10 years. Now I know the applicant's attorney didn't request it. They're in settlement mode. So why should these lien claimants be prevailing in situations like this? But I think the worst one is that first example, getting 3 subpoenas in the same year for the same location. You know that the applicant's attorney didn't request that. What's producing this fact pattern? Applicants' attorneys, I believe, have allowed copy services to use bots to scan their file management software. Anytime defendants subpoena something, copy service automatically orders it up. Now, is there actually a person over at the applicant's attorney's office typing, to the copy service, hey, can you pull those records for me? No, I don't think there is when this is going on. It's basically AI ordering up billing for the copy services. Now, there's other former applicants' attorneys out there who have been indicted for pay-for-play arrangements. If you talk to them, they will tell you that they swear that other applicants' attorneys are getting paid by referral fees by copy services. In other words, the copy service is paying the applicant's attorney a fee for every subpoena that's generated. And that's outright fraud, and it's illegal. It's extremely difficult to prove. But a former applicant's attorney who did get nailed for that has communicated with me before, and he's testified in trials against other copy services for that. Now, while he's a bit dated, he swears that this practice is still going on. Solution, the legislature, Sacramento. We have these PTPs who are claiming that all treatment is med legal. That's just not true. It's treatment. We have copy services who are ordering up subpoenas when it's pretty apparent that the applicant's attorney has never asked for them. We have interpreters billing, 120 hours for a single weekday morning. I've had interpreters send us a bill for for example, for a status conference. They show up at the status conference, say they talk to the applicant, and then a month later, I find out that the applicant died 6 months ago. That's fraud. All of these guys are filing petitions for non-IBR. And this has reached the level of red ink where lobbyists need to show our lawmakers that it's rife with abuse, and it's reaching unacceptable cost. So I think that's where insurance carriers and TPAs, if you belong to a lobbyist organization, please bring these complaints to them, because this is causing you lots of red ink, and it's become a niche industry. And one thing I learned from working at WorkComp Central a long time is you would see these niche industries pop up every now and then where people are making millions and millions of dollars off a flaw in the system. Well, here we have a flaw, and it's definitely being exploited, and it's time for our lawmakers to do something about it. Nikki, any other interesting questions, by the way?
Yes. Are copy services required to provide the applicant's work orders? Do they need to be wet signatures on the orders? I see a lot of copy service work orders that have stamped or electronic signatures. How do we know if that was actually requested?
And you don't know if that was actually requested. I guess you could start taking depositions, but do you really want to do that in a case, with a few $100 of dates of service or $1,000? So that's that you end up reaching that endpoint of, do I really want to go fire and brimstone and start taking depositions, which are going to be fought tooth and nail, over whether the signature is authentic or not, or whether they actually ordered that stuff. And I should go back to an example. I know a sole practitioner very well. I'm on good terms with him. He's an applicant's attorney, and he is surprised and outraged that this is going on. When I see it, he doesn't issue many subpoenas. When he does, it's for something he thinks he needs. And I get it. If I have the records, I'll send them to him and I'll motion to quash. But if he needs it and I don't have it, then it's probably a legit subpoena. So it's not like all applicants' attorneys are doing this either. It's just some have these obvious arrangements with sketchy copy services who seem to be abusing the system here.
And another one was, are we responsible for subpoenas for cases that resolve via CNR, but it is requested by the AA for purposes for subsequent injuries benefit trust fund?
And I'm sorry, so the copy service is going to a subsequent injuries benefit trust fund issue?
Right.
That's kind of complex, but you're getting sent the bill for something that should be paid by the SIBTF. I see a pretty decent argument that why should you be liable for that? At the same time, I was listening to some SIBTF arguments this morning while I was at a hearing, and there are definitely issues that are being sorted out during the SIBTF disputes, and so that I could see that falling under the definition of mad legal if the SIBTF number or issue is still up in the air, because that's a disputed medical fact as far as like what percentage of PD do they have, or how much, what are they owed for that percentage of PD and that kind of thing. So I think in that situation, if it's not clear as to who's paying what, then it probably is compensable. But if it is clear that it's just going to the fund, then I don't think you should be owing that.
And there was one more
Okay.
that asked, what happens when we paid a reasonable rate, but not the full value on a copy service bill, and they are filing for the balance in full and interest?
And so I think that's where you just look to the copy service fee schedule, and you pull up the line item, in the fee schedule of what payment was appropriate. And if you paid that, great. If you paid less than that, then consider paying them the difference. But yeah, that is the nice thing about the fee schedule. As far as pre-copy service fee schedule cases, because a fee schedule did not always exist, what you want to do is I've made arguments that, hey, they're trying to bill me $10 a page for subpoenaed records. Judge, isn't that ridiculous? So for those copy service dates of service that are before the existence of the fee schedule, you can make arguments like that, try and get estimates of how much per page are they billing, and is that, that's unreasonable for this reason or that reason. And so yeah, that's really the way I would do that. But those fee schedules are useful. That's why they exist. So if they are billing for more than fee schedule, then use that fee schedule and throw it right back at them.
I just want to thank you, John, so much. You always do a fantastic job. And this was Nikki's first time helping with questions, and we had about 100 of them. So great job, Nikki. And
Thank you.
You did awesome. And I also wanted to apologize for any of you who had trouble signing in the beginning. We did get that issue resolved. And the issue is that there are just too many of you attending, and we're just having to keep extending how many people can register and attend. So it's a good problem to have. Thank you all so much for the fantastic questions today. We really appreciate it. You can register now for our September 24th webinar with Alec Bradford and Nicholas Ward. They're going to discuss supplemental job displacement benefits. We've never taught this publicly, so that'll be a great new topic. Webinar information is always located on our training page at bradfordbarthel.com. Certificates will be sent out this afternoon. Thank you so much. We appreciate you all. Have a wonderful rest of your week. Take care, everyone.
Thank you, everybody.
Bye. Thank you.